Welcome to Business SOS Podcast. This is Rich Sierra, President of the Florida Small Business Legal Center. This is episode 76 of Business SOS. We're excited that you're listening to us, and thank you for listening. Today, we're going to talk about 10 fatal mistakes to avoid in litigation. As you know, I'm doing the theme of 10, the 10 topics or 10 mistakes to avoid, and it's kind of a theme that I've been having this year. So certainly I'm excited to share these tips with you. Before I start, if you want to contact me, you can send me an email at richsierra.com. Again, it's rich, R-I-C-H, at richsierra.com. If you have any legal questions, anything you'd like me to address in the show, please send it to me. And if I select your question, I address it in the show. I'll send you a free copy of my book, Business SOS, Common Legal Mistakes Business Owners Make and How to Avoid Them, which is available on Amazon, Barnes & Noble. You can also ask for it in your local bookstores. Also, if you're interested in learning more about our legal services, my website is floridasmallbusinesslegalcenter.com. So let's start it. Today, 10 topics, 10 fatal mistakes to avoid in litigation. As you know, I am a litigation attorney. I've been doing this now for 20 years, and I've had, thousands of litigation cases. So I want to tell you some of the mistakes that are made commonly that are what I call unforced errors. That really, if these mistakes are made, you have a possibility of losing your case. It can cost you more money, and there are things that can be avoided in the litigation process. Here in South Florida, litigations can take, anything between 12 to 24 months. Now that's kind of the standard right now. Also, obviously, the case settles sooner. It can be less time, but it's a litigation process. It's not what you see on TV. You have a dispute and then you go straight to trial, and 30 minutes later. It doesn't happen that way in real life. So there's a lot of process, a lot of procedures that we got to follow throughout the course of litigation. That it is to a degree. I don't want to use the word game, but it's the only game, the word that comes to mind. That is a lot of gamemanship, a lot of strategy, a lot of deadlines that we have to meet, a lot of rules. So we have to follow those, and you want to avoid certain mistakes, and I want to get right into it. So Business SOS tip number one is doing your own legal work. That is a mistake that many business owners make. They try to do their own legal work now that you have access to information on the web, and now you have access to more information through ChatGPT and other AI models. So business owners are trying to find a way to shortcut or perhaps bypass an attorney, and they begin to do their own legal work in answering lawsuits and doing legal research. And unfortunately, that leads to even more mistakes, especially number one, if you are a business owner and you have a legal entity like an LLC, or you have a corporation, a sub-S corporation, unless you're in small claims, you have to have an attorney to represent you in the lawsuit. So whatever work you're doing and responding to the lawsuit, most likely it's going to be stricken by the court. So you're completely wasting your time if you're trying to do your own legal work with respect to litigation. The best thing to do, and I said this before, and many times throughout, the year and a half that I've been doing this podcast, that if you're involved in a lawsuit, the best thing you can do for yourself is contact an attorney. Get the consultation, hire the attorney that you're comfortable with, to be able to take on that litigation for you and represent you in this case. But a mistake that I see often is that, business owners trying to help themselves and do, DIY type project in litigation is a mistake that certainly I recommend not to do it, simply because it can be a fatal mistake to your case. What have consequences of doing so is that you can waive defenses. You can also make admissions that you didn't have to make before. And at the end, most likely that will be stricken. And then you got to have another attorney to come in and undo the work you did, which will cost you even more money than if you would have hired an attorney right in the first place. So, business SOS tip number 2, not meeting discovery deadlines. Their discovery is important in litigation. Specifically, you're dealing with requests for production of documents, requests for admissions, and requests for interrogatories. So you have requests for production of documents. The other side, if you're a defendant in the case, the plaintiff will send a list of documents that he or she will request from you to be submitted as part of the evidence process of the preparation for trial. An example would be any documents which relate to the contract that you sign in this particular day with this particular party. Any email communication or text messages and text messages that you exchange with this party which relate or refer to this particular dispute. So I'm just giving you kind of an example of the type of documents that most likely would be asked in a business litigation case. And you also have interrogatories. Interrogatories are just questions that you will answer under oath, and also requests for admissions that they will ask to admit certain facts in order to try to get you to prepare for trial and to get to admit those items that they're requesting you to admit or deny. In most jurisdictions, in fact, I'm pretty sure Florida it is the case. In the federal court as well, you have 30 days to answer what is called written discovery. So from our perspective as attorneys, when we send it to the client, we need it back in 15 days or less. It cannot be sent to us at the 29th day of the 30th day that it's due, because we have to go through your answers. We have to make sure the answers are correct, they're complete. We need to look at your discovery, the documents that they're requesting, the documents that you're sending, and match them to the specific request. Sometimes you can get requests that are approximately talking about 30 to 50 requests. So you send us a bunch of documents that are not labeled. They say, here are a bunch of emails, 100 emails. That's all I have, but we don't know to which particular request they refer to. So that's very time consuming. So you give it to us at the end of the deadline period, it's just not possible for an attorney or a paralegal in one day to organize that material in such a way that complies with the rules and you submit it to opposing counsel. Worse off is that if you don't even submit it at all to us, to the attorney, or you submit it late, which inevitably puts a tremendous time crunch on the law firm, on the attorney, and the attorney has to file a motion for extension of time to respond to a discovery, call the opposing counsel, ask for a favor. Hey, listen, do you agree that can I submit this discovery 10 days after the deadline? They usually get an agreed order, and then most likely you have to reciprocate when opposing counsel requests that from you as well. So those are enforced errors that can be avoided, and the requests for admissions are very important. Those are very simple. There's no excuse for them not to answer those within 30 days, simply because you're admitting or denying. And if you do not admit those, you do not respond to those within the time period, they can be deemed admitted by the court. So those admissions are not on the favor of the person who's receiving those admissions. So you want to meet those deadlines. Business SOS tip number 3. Another mistake that I see is ignoring your attorney's recommendation. Happens often, and there are consequences to that. When you hire your attorney, the attorney is a subject matter expert on the field that you hire that attorney, and you hire the attorney to help you resolve that legal problem that you have at the time, whether it's a litigation matter, whether it's a contract matter, and the attorney brings not only the knowledge of the degree that the attorney has, but also the experience the attorney has handling these types of cases. So when you begin to ignore those recommendations, then it becomes an issue that you're not allowing the attorney to do the type of work that he or she wants to do for you. And if you do not agree with the attorney's recommendations, it's good to have a discussion about it and see to make sure that both of you are on the same page. That's extremely important. So there's and there's some maybe minor disagreements. There are major disagreements, but it's important that both of you are on the same page. And if the attorney gives you a recommendation, follow it. And if you don't agree with it, talk about it. So that way to see whether that disagreement can be ironed out, and then you can move forward with the recommendation. There's also a risk by not following the recommendation that if it happens very often, or the advice that the attorney is giving you is significant, it's very material to the case, you choose not to follow it, you're running the risk that the attorney may decide, I cannot continue representing you. And the attorney may end up withdrawing from the case, and then you got to hire another attorney to take over the case. So it's important that these differences of opinions are addressed, and you have consultation, and you have to make sure that you're both on the same side, on the same page, with reference to resolving your dispute. Business SOS tip number 4, not responding timely to attorney's request for meetings or information timely, which goes into the discovery deadlines, but also sometimes, there might be a follow-up call, there might be a status meeting that we request, and then, you don't become available, you're traveling, you're not available for 3 weeks, and we have deadlines to meet. So when an attorney calls you, or attorney's office calls you or emails you, listen, the attorney wants 15 minutes with you to talk about the case, try to make yourself available at that time. Attorneys are very busy. Successful attorneys are busy. So if they're carving out time for your case in their calendars because it's important, so and you're paying this attorney for the services, so you want to make yourself available for that phone call, that email, and to make sure that you have the consultation, the conversation that he or she wants to have with you. There's also repeated requests will cost you money. If it's a situation that the attorney keeps trying to follow up with you, let's have a meeting, you don't respond, let's have a meeting, he sends you an email asking for information, you don't respond to it, at some point the attorney is going to begin to charge you for those requests. And if you become uncooperative or non-responsive, the attorney is taking the risk that might miss a deadline for you, or worse, the attorney say, listen, I cannot continue working with you because you're not giving me the feedback that I need to advance your case and represent you. So again, it's another enforced error. It's not responding timely to attorney's requests for meetings or responding to emails. Business SOS tip number 5, not paying your attorney's bills. Goes without saying, the attorneys are also business owners. Many of them are small business owners. So as you're running your business, obviously your customers do not pay you. That has a financial impact on you and your business, your employees. The same thing with law firms. They're no different. We have employees, we have staff, we have overhead. So when the client does not pay our bills or does not pay us on time, it does have a financial impact. So when you're, dealing with that, it's in a situation that you have an attorney's bill and it looks like you might not be able to make that bill on time, call the attorney and say, listen, let's let you know, don't call him the day that is due. Just call him a week before. I saw this bill. I want to pay you, but I don't know if I'm going to make it on that particular day. What can we work out? So maybe the attorney can work that in a smaller payment, split that bill for you. But communication is key with respect to paying an attorney. If you have any questions about the bill, ask the attorney, listen, what about this charge? What happened here? Is there any way you can, when you have a certain threshold on the amount of the bill, can you send it to me as opposed to let it escalate to a larger amount that it becomes more difficult to meet at a certain point? So that is an enforced error because at some point, if that continues, then the attorney will no longer be able to provide you legal services. And if I believe that the last episode that we had in the podcast, episode 75, we dealt with collections, so as well. So if the consequence of not paying the bill, then the attorney will have to withdraw from the case, and that's simply you don't want that to happen, because then the other attorney is going to ask you what happened with that attorney, and then if there's going to be a red flag for a new counsel to come in if you're not paying your attorney's bills. So that's an unforced error that definitely can be avoided. Business SOS tip number 6, trying to co-counsel, quote unquote, in your own case. Again, as I said before, with the availability of information online, and I know that people want to be helpful, and this is done with the greatest of intentions. But when you begin to send legal research to your attorney from other sources, or interrogatory questions that you generated through ChatGPT, and you begin to bombard your attorney with information, it becomes confusing and overwhelming. Simply because your attorney already has a certain framework in how he or she works. And there are certain legal libraries that we all use that are vetted, and they're the ones that are recognized by the courts that are reliable. There's also, with our experience in business litigation, we know what questions to ask, we know how to request information, and we know how to research the law. So what happens is that you start getting cases from different states. You start getting cases from federal court when it's a state court case. And you start getting, I've gotten motions sent to me by clients, and I know it is appreciated, and it's and I know it's done with a grace of intention, but what happens is that it distracts the attorney from the case, and then you begin to start talking with the attorney about what you submitted. And that's counterproductive because, number one, it's going to cost you money. Most likely the attorney is not going to use that material. However, if you have information, factual information about the case that you want to share with your attorney, absolutely. Because in any type of litigation case, or especially partnerships, contracts, you know the facts. We don't know the facts as well as you do, because you lived the event. You lived what happened. You lived the event that triggered that controversy. So any type of factual information you want to provide, absolutely, because that's helpful to the case, and sometimes even information that you might have forgotten, which, is human nature, or I forgot about tell you about this, or I remember this email, this text, send it. That's welcome, because those are facts that could help your case. Business SOS tip number 7. Arguing with opposing counsel and the judge. They're going to be, if you're in a business litigation case or civil case, very likely there'll be a deposition that will be taken from you, that you'll have to answer questions under oath and from the opposing attorney. It is an adversarial process. So you're not going to like the other attorney side. You're not going to like the other side, the attorney of the person who's suing you, or the person that you are suing. So you're not going to be happy with the fact that you have to sit there. Your attorney can only do some certain objections. He cannot coach you. He cannot tell you how to answer the questions. So you're going to be there basically answering questions on the road by somebody who wants to elicit questions from you in order to prove his or her case against you. So you're not going to be happy about it. It's not going to be a pleasant situation. But getting into an argument with opposing counsel is not helpful. Getting belligerent with opposing counsel is not going to be helpful to you. It sends the wrong message, and in fact, it might help their case, especially if it's via video, So a lot of times now they're doing video depositions, and if they are able to get under your skin and get you angry, say something that you may not have said otherwise, in your deposition and video, they have something they can show the jury or the judge in the event a trial. So it is not helpful to do that. It is not productive to do that. So I recommend that if you're in a situation that you're getting worked up in a deposition, just, at the proper time, ask for a 5-minute break so you can regain your composure, and then you continue going back into your deposition testimony. And if you recall various podcasts back, I did a whole podcast focusing on deposition questions or deposition, how to prepare for a deposition and common mistakes business owners make during a deposition. So if you want to take a look at that one and review it, if you're interested in that one. But arguing with opposing counsel does not help. Another mistake that I see sometimes is that sometimes you, as the party, have to appear in front of the judge, whether it's an evidentiary hearing, whether it's a bench trial that is done via Zoom or even in person and actually live in the courthouse. So when you as the client begin to get angry with the judge and begin to argue with the judge, that is just extremely, it's just not helpful. It can be detrimental to your case, especially the judge. The judge is going to have rulings. And the last thing you want is for the judge to remember you in a negative light. Out of 2,000 or 3,000 cases they have, and you show up in the Zoom and say, I remember you. You don't want that, okay? So the best case scenario is to have treat judges with deference and respect that they deserve, and not to argue with the judge. The judge asks you a question, you answer it, very factual, but there's no need to become angry or belligerent or start arguing with the judge, because the judges have they rule, they preside, and that doesn't go well. And actually, you can be sanctioned if indeed you don't obey a judge's order. So composure and civility is the key here. So it's that's a mistake that sometimes people make, and it is an enforced error, absolutely, that it can be harmful to your case. Business SOS tip number 8, withholding information from your attorney. I kind of alluded to that just a few minutes ago. It is important to tell your attorney the good, the bad, and the ugly in your case. That's extremely important. I'd rather deal with bad news right from the very beginning in the case, because then I can develop strategies and handle that. But the last thing you want is that you're in a deposition, and then opposing counsel puts out an email in front of you to ask you about a specific email or text message that your attorney has not seen before. That it's the very first time that that email was presented, and that's the very first time the attorney sees it. Okay? The attorney has not developed a strategy how to handle that, and at the deposition, there's nothing the attorney can do, pretty much, unless it's something privileged, confidential between the attorney and the client. If it's something relevant to the case between the parties, it's going to go in. So by not telling the attorney that, then the attorney's going to question, is there anything else you have not told me about the case that I need to know? And it's going to ask you why you did not share this with me. I forgot. I didn't think I have it. I forgot that email existed. If it's an email that is going to be shown on the deposition, most likely you have it, especially if it's exchanged. So it's important when your attorney asks you, look at all the emails that you have and send them to me, that you're thorough. And, if there's a mistake, those things happen, but you're thorough because it can only help your case. Your attorney needs to review all the documents that are relevant in order to help your case. but forgetting an important text message, or worse, choosing not to provide it to your attorney uh, because you might be embarrassed or because it might be an admission of liability, let the attorney know. Don't withhold it. The attorney will develop strategies how to handle that and recommendations how to handle that piece of bad information. But I'd rather have bad information tell me from you from the very beginning as opposed to on a deposition that I find that as a surprise and I have no idea where that came from or because I was not told. So it's important to tell your attorney everything, good, bad, and the ugly. And I'm talking in the context of business litigation. That's what I do. There might be other areas. I let other attorneys handle that. But my preference is tell me the bad news from the very beginning. How did this happen? We'll figure out a way to address it if we can. There's also another consequence to not sharing the information with your attorney. If in most retainer agreements, and we have it in ours, that if there's a misrepresentation made to us with respect to aspects of the case or material omission that should have been presented to us as we're advancing your case, we have the right to withdraw from the case. You agree that we have the right to withdraw from the case if it's something that's significant. So not sharing information with your attorney would have that consequence. Business SOS tip number 9. I addressed this a little bit earlier on, is providing incomplete responses to discovery requests. This is it's a little bit different than withholding information. Discovery requests can be overwhelming. They're designed to be that way. The opposite side is designed. The opposing side sends you interrogatories and production requests because they want a lot of information from you, but also becomes a psychological tool to really put pressure on you because you can answer all these 30 questions. A lot of them are repetitive. A lot of them you don't even understand what they mean. So it really creates a lot of work for your attorney to decipher or interpret these questions for you to answer them in a coherent fashion. The same thing with discovery, with documents. So, as I said before, if you have a discovery item, it's important to do it in advance and provide it to your attorney as soon as you can, no later than 15 days from the due date, so the attorney has 2 weeks to begin to work with that and provide a good final product for you. At the last minute, it will not work. Then you ask for extensions, as I mentioned before, but you want to be as thorough as you can. And the procedure that we follow is that, we send you the discovery. What you recognize that you have, begin to present it to us, identify it. This is for request number 1, request number 5, 6, 7, 8, whatever the case may be. The ones that you do not have, tell us, I don't have this information, because the reality is when they ask those questions, this request, it doesn't mean the attorney knows whether you have or you do not have. So they cast a wide net of questions in order to see what they can find in reference to a discovery. If one discovery request answers several requests, you say, listen, this is for request 2, answers 5 and 5, 7. Fine. If there's something you do not understand, just say, I'm not sure about these items. We'll go over them, begin to narrow it down, and that's going to help us prepare the response. The same thing with the interrogatories, and the same thing with requests for admissions. But the key here is to do that early. Let's not wait till the last minute, to allow your attorney the proper time to complete the discovery and provide a good final product to present to opposing counsel in their response. Business SOS tip number 10, refusing to consider settlement options. The reality is that most business litigation cases settle. That's a reality. Very few of them go all the way to trial in court. A number of reasons, but we went over that early on. Could be most of the times it's financial reasons. The plaintiffs and defendants, being business owners, are recognize that a long protracted litigation is going to cost a lot of money. And in many cases, the cost of litigation will exceed the potential reward at the end, the potential judgment at the end. or some. So there's a risk management analysis that has to be made here. How much money am I going to spend in this litigation to have the possibility of getting a judgment at the end, which most likely will be appealed, and there's no guarantees of collection. The same thing if you're on the receiving side, if you're the defense side, how much money am I going to spend in this litigation in reference to what is my worst case scenario? And you weigh that out, and your attorney will help you with that analysis. But it is important to consider settlement options, especially if your attorney recommends those. Your attorney is looking at the big picture. We'll look at the immediate, we'll look at midterm, we'll look at the big picture here. What are possible scenarios? And a settlement is a compromise. You're not going to be happy with the potential settlement, and the other side is not going to be happy with the potential settlement. But the reality is that if both parties agree on a settlement, it could be better off than going to court. It's more predictable, and you have complete control of the process. Whereas if you allow a judge or a jury to make the decisions for you, one person will be a winner, one person will be a loser. There's no middle ground here. Or the judge will make a decision, and nobody's going to like the outcome. Very seldom. So you have control of the process when you agree to a settlement, but in this particular case, is refusing to consider the possibility. Nobody's telling you got to agree to settle the case, but refusing to consider the possibility is a mistake because as business owners, you want to make pragmatic decisions for your business. I have one more for you. This is a bonus tip. Business SOS tip number 11. Discussing your case with family and friends. This happens often, and I should have brought it up a little earlier. The people want to help. It is important for you to know that when you're talking to an attorney, it is that communication is protected by attorney-client privilege. So nobody can, there's some exceptions, we don't have to go over that, but for the most part, the communication you have with your lawyer is private and confidential, and nobody can ask, your attorney to testify as to what the attorney told you in that communication, whether it's email, text, phone, doesn't matter, letters. That communication is private. The same way, your communication, whatever you told your attorney, is private and confidential. Now, what happens in some cases is that people are well-intended and start telling friends and family about the case. They start sharing documents. They start sharing strategy. The exception here, you can tell your spouse, a spousal privilege, that the spouse cannot be asked to testify about what you communicated with the case because of spousal privilege. But telling your neighbor, telling your friend, telling your brother, sister, or some other friend that happens to be an attorney, that attorney's not in the case. That attorney could actually be called in to testify. So you're waiving attorney-client privilege by doing so. And one of the questions that we ask in our deposition, and it's very frequently asked, is, have you spoken to anybody about this case? And we ask those questions. I said, what have you told so-and-so? When about that communication? Do you send a text message about the communication to that person? You send an email? And the answer is yes. Guess what? That individual that you spoke to about the case can be called in to testify against you. And you end up sharing the communication that your lawyer told you. And you're, in essence, waiving attorney-client communication by doing so. So it is important to know that whatever communication you have with your lawyer has to stay with your attorney and don't share it with anyone. So that's very important for you to know. And just to recap very briefly some of the tips that we talked about today. Tip number 1, doing your own legal work, don't do it. Tip number 2, not meeting discovery deadlines. Tip number 3, ignoring your attorney's recommendations. Tip number 4, not responding timely to attorney's requests for meetings or information timely. Tip number 5, not paying your attorney bills on time. Tip number 6, trying to call counsel on your own case. Number 7, arguing with opposing counsel and the judge. Number 8, withholding information from your attorney. Number 9, providing incomplete responses to discovery request. Number 10, refusing to consider settlement options. Number 11, discussing your case with family and friends, and waiving attorney-client communication. These are fatal mistakes to avoid in litigation. I think that's good for today. If you want to reach me, you can reach me at richsierra.com. If you want to learn more about my legal services that we offer, my website is floridasmallbusinesslegalcenter.com. If you want to watch the video of this podcast, you can go to youtube.com/@RichardSierra. We're on X at Rich_Sierra. We're on Instagram at FSB Legal. Again, it's F as in Frank, SB Legal. If you want to give us a call, the number is 866-842-5202. Remember that Business SOS, 8 common legal mistakes business owners make and how to avoid them. It's available on Amazon, Barnes & Noble. You can ask for your local bookstores as well. If you like the podcast, please share it with your friends. Appreciate a review. Appreciate a 5-star review. And follow us on Apple Podcasts, Spotify, wherever you enjoy your shows. One more time, if you're interested in the book, Business SOS, 8 Common Legal Mistakes business owners make and how to avoid them, it's available on Amazon, Barnes & Noble. You can ask for your local bookstores. Until next week, this is Rich Sierra with the Florida Small Business Legal Center. Remember that my goal is to help you succeed.